then it's the second issue is abuse of court versus undue delay. I'll explain that when I deal with the merits.
Yeah.
Then the third issue is what we call Kumalo principle versus Gijima principle. I'll also explain that. It's in our heads. I'll explain it when we deal with the merits.
Yes.
Then the fourth issue, JP, is irrationality of the non-prosecution decision. That's now on the merits.
Yes.
And then the last issue is the failure to give reasons.
Right.
Yes. Okay. So starting with the first issue, then on which I will take exactly 5 minutes. JP, we must start by apologizing for the fact that, as both to the court, of course, and to the other side, for the fact that the application was about 30 working court days late, and the explanation that has been given by the attorney. Well, there's an explanation by the attorney, and then there's an explanation by us, because we also owe a duty to the court as counsel. But the main application, really, rather the main ground, is that the attorneys took much longer than anticipated to round up the applicants. Now, it might well be, as my learned friends have indicated, that maybe the explanation is given in cryptic terms, but the reality is that the court can take judicial notice of the fact that these applicants are migrant workers. That's how the whole strike started, and over a period of 10 to 12 years. Some of them have gone back to where they originally came from, and it's not as easy as when they were all sitting in Rustenburg to obtain instructions. And it was really that kind of logistic that created the extra time that was needed. So that was on the side of the attorneys. On the side of counsel, as we have explained, normally we assist because of those logistical nightmares. So we would say, you do this 10 and do this 5 and so on. But we were not able to do so because even ourselves at that time we were involved in quite a number of other litigation. But that really is the end of the beginning and end of the reasons that have been proffered for the. It's common cause that these are multiple applicants, about 20 of them. And by the way, just to illustrate the kinds of developments that have occurred over the large number of years, I could just say, even from the bar, that, for example, the 6th applicant, Mr. Tolakele Zunga, was murdered and he died about a year or so ago. So there've been all those kinds of, and I think he had already gone back to the Eastern Cape and he was gunned down there. But the reality, the point I'm really trying to make is that the people are now spread out, and it's not easy to find them, to have found them within the 15 days that is allowed in the rules. That's
let me just ask you this. I mean, we live in a fast-paced world these days where there's electronic media and there's cell phone usage and whatever. Yes. There's nothing in your papers that says whether they have cell numbers, someone tried to call them on their cell numbers to coordinate the effort. Should one make anything out of that?
Yes, no, JP, as I said, I'm the first one to admit that much more detail could have been given in the affidavit. But in my respectful submission, the gist of the logistics, I mean, the attorney doesn't say, yes, I phoned this one on such and such a date, or I went to this province or whatever, or I phoned this one and the number had changed. I admit that is not done. But the gist of the fact that because of the number of people and because they were spread out throughout the country, it became literally impossible to do it within the 15 days set out in the rules, given the numbers that we're talking about. And as I said, the realities of migrant labor in South Africa and all that. That is an explanation that we pray that the court should accept.
No problem. No, thank you very much. Is that it on the condonation?
Yes, that's it on the condonation, JP. And we of course we would also say that the court should really view the plight of these particular applicants with a degree of leniency, given the ordeal that they have suffered over these years. And as I say, their number and origins.
Yes. Please continue.
Thank you. Now, coming to the merits, Honorable Judge President, we really would like some of these issues have been succinctly put in the heads, so I'm not going to give a lot of background. The first crisp issue that we wish to raise is one that, at face value looks like it's simple, but it is not.
Yeah.
And it is this, and it's the one we call abuse of court versus undue delay. Yeah. You'll remember that the issue of undue delay was actually not raised by the respondents. I'm sorry, the issue of abuse of court was not raised by the respondents, yes.
Yes.
And the point in limine that was raised by the respondents was undue delay. Now, I'm not saying that the two things are not related, and the judgment clearly relates those two things, and there's nothing wrong from a logical point in relating the two things, because after all, an undue delay might, in certain circumstances, graduate, as it were, to abuse of court. That's not. I'm not disputing that. Yeah. The only point I need to raise is simply that we know the law of abuse of court is, by definition, it's applied in very rare and exceptional circumstances. Why is that so? That is because at face value, and this was said in a recent case, Mineral Sands, which I haven't referred to, is a constitutional court case. It was said that, yes, it was said that even in a case where you have a good case, in other words, you might have a great case, your legs were broken and what have you, the court can still dismiss your claim simply on the basis of abuse of court.
Yeah.
Now, and we know the reasons for that. But the point I'm making is that it is such a drastic remedy that if you can even deny someone with a good case, basically non-suit them, then surely that is something that must be done when everything else has failed. So it's tried that its abuse of court must be only applied in such exceptional circumstances. Now, here's the question. The question is, I've looked through all the cases and I've not found any case where abuse of court is used to dismiss a claim when it is not pleaded by anybody, when it has not been raised by the other side, as it were, and it has been raised by the court Meromotu. Now, it might well be that the court is allowed to do that. I'm not saying that it is not. The point I'm making is that if that is a development of our law, that certain egregious forms of abuse of court are such that they might be granted even if they are not pleaded, well, then that is definitely something that needs to be taken upstairs, not something that can be decided by a single judge sitting alone Whether it's good or bad is another point. I'm simply saying that that alone means that it's something that, as you said, JP, we're not here to re-argue the case. It's simply to demonstrate that it should go to a higher court. So that's the submission we make on the abuse of court. And for authority for that is there are many authorities. There's Mulauti's case, but Mulauti's case is Mulauti versus the state. That's 2015 8 BCLR 904. No, I'm sorry. Let me give you yes, okay. 904 is that ACC, but there's also an SACR reference 2015 bracket 2 SACR 341 CC. That Mulauti's case was relied on in by the SCA in GNUOP. That's the GNUOP versus Gupta case 2021 bracket 3 SA 135. And it says this that
at what paragraph?
At paragraph 32, JP, 32, yes.
Okay, yes.
The Constitutional Court pointed out in Mulauti that the inherent power of courts to regulate their process does not apply to substantive rights, but rather to procedural and adjectival rights. And here's the point, JP. What we're saying is that to the extent that the court relied on Section 173, and that's that might even be a standalone ground of appeal. The Section 173 only extends to procedural latitude, for lack of a better word. Yeah. So one cannot then deny a substantive right under Section 34 of the Constitution, or PAJA or whatever grounds is relied on, by invoking Section 173. Section 173 in this context is confined to situations where there's a procedural lacuna and the rules don't provide for a particular unforeseeable situation. Then the court is entitled to regulate its own process. So the word process by definition means procedure. So that's that's a related ground to the abuse of court process. The second point, JP, is what we call the Gijima versus Khumalo principle. Here we say that the court relied, as clearly stated in the judgment, on the Khumalo principle. The Khumalo principle, we all know, says that if there's undue delay, I'm now confining it as far as undue delay is concerned. It says if there's undue delay, you must show that it was not unreasonable and so on, the usual parameters. But what the court, with the greatest respect, overlooked was the fact that the Khumalo test has now been overtaken by what we call the Gijima principle. And the Gijima principle says this, paraphrased: even in the case of undue delay of, and I'm exaggerating, 100 years, if it can be shown that there was a breach of the of a constitutional right in the mode of Section 172(1)(a. In other words, if apart from the undue delay, there would have been a conduct or law that is inconsistent with the Constitution, then the court must overlook the delay. It sounds, and there's been a lot of academic...
You say if it can be shown What?
Yes. Let me. I'm trying to find. You'll find the best articulation of this in the ASLA court case, JP. That is in our hands. Buffalo City versus ASLA Construction, 2019 4 SA 331. And that.
Yeah, I think you've mentioned these cases. I think because these are important principles you cite.
Yes.
If at some stage your junior or your attorneys can just upload them onto the file.
Yes, we'll do that. We'll do that. Yeah. Yes, we'll do that, JP. But let me just because, so for the sake of time now, I'll just it's discussed in many places in the ASLA court by the Constitutional Court. Teron J was the judge, but I'll just read one paragraph which just gives a kind of a gist of the.
Yeah.
Paragraph 63 of ASLA. It says the fourth principle stems directly from Gijima, and this is how it's articulated there. Even where there is no basis for a court to overlook an unreasonable delay, the court may nevertheless be constitutionally compelled to declare the state's conduct unlawful. This is because, quote, Section 172(1)(a) of the Constitution enjoins a court to declare invalid any law or conduct that it finds to be inconsistent with the Constitution. And the reference is on the Gijima case itself. So that's the principle. And then I'll jump a lot of things and go to paragraph 101 of that judgment. Yeah. So the parts that I've jumped is where the court was actually looking at a particular delay and found, as it happened, as this court did, and found that that delay was not justifiable. But then the court said at paragraph 101, however, this is not the end of the inquiry. And that's where, in our respectful submission, this court erred, and because it was regarded as the end of the inquiry. It says, on the authority of Gijima, said Teron at paragraph 101, this court must, having established that the resting contract was clearly unlawful on undisputed facts, declare it invalid in terms of provision of 172(1)(a) and set it aside. The unlawfulness cannot be ignored to set aside a contract that it knows to be unlawful. Okay, yeah. So those two paragraphs just illustrate what the principle is. And the principle may or may not be applicable or totally enforced with this particular matter. That's not what we're arguing. What we're arguing is that the mere reliance on the, shall we say, outdated Kumalo test and without taking into account the Gijima test is sufficient ground for leave to be or to appeal to be granted. Whether we'll succeed even on the Gijima test in the higher court is another question. Yeah. Right. Now, then the third or the fourth ground, excluding the condonation point, is our submissions around what we call the irrationality of the non-prosecution decision. This is now going into the merits of the review. Yeah. And in our respectful submission, the rationality in the legal sense of the non-prosecution decision, and we admit, of course, the judgment is correct to say that, generally speaking, there are separation of powers issues. A court should be slow to interfere and so on. We don't quibble with that. But what we say is that since it seems as if the it's accepted by everyone that the heart of the state case, I'm now talking about the criminal case, relies on the evidence of this so-called Mr. X.
Yeah.
And I know that Mr. My learned friend is going to say, no, but there's a long list of witnesses and so on. Yeah. But the point of the matter is that by the mere fact that even the NDPP entertained and wanted to know, to get Mr. X's evidence from the Falam Commission and so on, there's a general acceptance that if that witness is discredited, then the case might crumble, because he's the only quote unquote alleged eyewitness, and that is why in the representations, the accent was put on this issue of Mr. X, and to the credit of the NDPP, it was entertained. Now, in our respectful submission, the glib answer that just says, well, Mr. X, there were some redeeming features which were found by Judge Falam, is not enough, because if indeed that witness is completely without any credibility at face value, at least, then it means this entire expensive exercise is really intended to, it will end in a cul-de-sac, in the sense that if there's no reasonable prospects of success of the prosecution, then obviously the prosecution must not, as we saw yesterday with the Pala decision.
Yeah.
It's not to trivialize whatever is being alleged, but a prosecutor simply says, well, I just don't have credible evidence in my even if someone has been killed, it doesn't take away from the fact that someone has been killed and it's a serious offense. But if there's no evidence, there's no evidence. So that's where we attack the rationality.
The rationality, yeah. Yes,
of proceeding. Then the last point, Judge President, is a much more serious attack on the reasoning of the NDPP. And here we articulate it. If you go to the judgment, you'll find at paragraph 59, or let's say from paragraph 57 to the end, to 60, the court deals with this issue of the failure to provide reasons. And there are two issues that the court raises. One is, well, there was nothing much that changed from the first representations to the second. And therefore, the mere fact that in the second response, admittedly, there are no reasons that are given, really. It simply says, I remain unpersuaded. And the court says, well, that might be inadequate, but since there were no new developments, one should refer to the earlier letter. Now, with the greatest respect, we submit that another court might differ with that approach, in the sense that there was an important intervening event, which was the meeting between the two parties. And unless, if it can be shown that that meeting really was meaningless or did not raise any new issues, it was not acceptable, to put it mildly, for the NPA not to give new reasons or adjusted reasons and simply say, well, I remain unmoved. So that's the first point. Yeah. The second point is the one that I say is much more serious, and it is this. Your Lordship said at paragraph 59, those reasons, actually, I'm reading from the middle. those reasons actually explain, even though somewhat terse. So the court was obviously clear that the reasons were not really adequate, but it says that the NDPP had considered the documents that served before the Northwest and DPP before he decided to continue with the applicant's prosecution. And here's the important part. In any event, the NDPP has, in the answering affidavit, fully substantiated his reasons for refusing to review and discontinue the prosecution. Now, that approach of the court, with the greatest respect, has been found to be wanting by the SCA. Just trying to see if there's also a constitutional court judgment, but at least by the SCA in 3 cases. The first case is National Lotteries Board. Just check if it's on our list. Yes, it's on our list of authorities at the end of our heads. It's number 3.
Yeah. What paragraph? Is there a paragraph you want to refer to, or a number of paragraphs?
Okay. JP, in the heads themselves, you'll find it at paragraph.
No, I'm looking for the paragraph in the case.
Oh, I'm sorry. Yes.
Where in the case that you are referring to.
Yes. It's 27 and 28. And I'll paraphrase again.
What did the SCA say?
Yes. In that case, I think it was Kachalia AJA, as he was then. He basically said our case on reasons should mimic or at least follow what is said in English law, namely that once you've given reasons, you can't then rely on reasons given in the answering affidavit, as the court did here. Why is that so? The court developed a concept called ex post facto rationalization. Okay. And apart, that's just big English, but what the court was really saying is that, and in the Zuma case, sorry, I'll come back to it now, JP. But the other 2 cases, if I can just give you the citations, it's Zuma versus Democratic Alliance.
That one is in your head, I think.
Yes, that one is in our heads. And then the other one is Umgeni Water versus Sembcorp. Yeah. That's also in our heads, yes. That so the Zuma was NAFSA ADP, I think, as it was. Umgeni Water was Wallis JA. And both the Zuma and the Umgeni cases effectively affirmed the position which had been put tentatively by Kachalia AJA. And now let me paraphrase the principle. So the principle is that if a party asks you for reasons, which was specifically done in this case, JP will remember the letters that we wrote to the NDPP asking. If a party asks for reasons after doing representations, then it is those reasons that are granted that must be considered. Any other reasons that are given thereafter, because some clever lawyers have now found other plausible reasons in the answering affidavit, must be discarded, because those extra reasons could not have been the ones that informed the decision, clearly for obvious reasons. Yeah.
Okay.
So that's the last ground then, where we're saying this court is bound by the SCA authority on that principle. And so in sum, we say 1, the abuse of process was not pleaded, and and Section 173 therefore cannot be applied. 2, for all the other reasons I've said. Secondly, we say that the Gijima principle overtook the Kumalo principle. on undue delay. Thirdly, we say that the lack of credibility of Mr. X's evidence ought reasonably to have saved all of us from a lengthy trial that might come to nothing. And then finally, we say that the consideration of reasons which were offered ex post facto offense against the SCA principle in those three cases. Okay. Those are our grounds as the court places. And then finally, sorry, JP, I forgot just one. On compelling grounds, yes. It really is just to say that this is a matter that has really lasted for literally 12 years. We accept that this particular court is dealing with the 6 years delay, but in reality, we all know that this is the so-called Maracana massacre happened in 2016, in 2012, so which is 12 years ago. The second issue is that even we accept again that we are dominus litis, and we're not here to deny that we contributed to the delay. But what we say is that even this court has found that the respondents were also to blame. It might be that we are more to blame and so on, but the respondents were also in pari delicto in a sense, in the sense that they could have brought the matter to court much earlier. And as I say, I want to make it clear, I'm not shifting the blame to the respondents. I'm simply saying one of the compelling factors to be taken into account is that they also could have expedited the matter. And then finally, it's the judgment of the Mafikeng court, which has effectively found that this the undue delay here is prejudicial to the applicants. So we raise only those issues only under the umbrella of other compelling reasons as a court basis.
Okay. And costs, you don't want to disturb?
Costs in the appeal. Costs in the appeal.
Okay.
Yes, it's the court.
Okay. Thank you very much. Advocate Matebesi?
Thank you very much, JP. JP, we have filed heads of argument. You will find them on case lines 018. We do not intend to re-argue the matter, as we say in our heads of argument. Neither do we intend to go through the heads of argument as they are. We will simply summarize what we say in our heads of argument in relation to this. Firstly, JP, the matter that is before you raises two issues. The first one is condonation. We've made our case for condonation. The simple thing we say on condonation is this. There is no explanation whatsoever of what the attorney did after getting the judgment.
Yeah.
In an attempt to contact the clients. All that he says is that some of these clients are coming from outside South Africa, which is in fact false, because none of them comes from outside South Africa.
Yeah.
And he says, I have had difficulty to get instructions, but what are the attempts that he had made to get those instructions? They are not said in the affidavit anyway. Then now the applicants are arguing and are saying there were also issues that involved counsel that they raise also in their heads of argument. But you will not find that in their affidavit explaining the delay. It's just an issue that they raise now in argument, and they've deprived the respondents of an opportunity to deal with that. So that's an issue that this court should not even consider. So we submit that there's no case made whatsoever for the condonation by the applicants. They are obviously doing the same thing that they have done in running this matter. Once more, even on the appeal, leave to appeal stage, they are doing the same thing of delaying the matter for their benefit, obviously, because they know that the charges have now been provisionally withdrawn because of this application. But we submit that a case has not been made whatsoever for the condonation of the late filing of the leave to appeal.
Yeah.
But we leave that in the hands of the court because we want to see the matter being finalized. it is in the interest of all the parties that the matter should be finalized. Obviously, I'm quite alive to the fact that the court will consider that issue, that the matter really must see its end on its merits rather than on the condonation. But we leave it to the court to decide on that issue. Here's an important issue then. Section 173, we say in our words of argument, Section 173, the court in dealing with a Section 173 inquiry, in essence, exercises a discretion. Now, for the appeal court to interfere with that discretion, there are certain principles that are tried. It cannot easily interfere with that discretion unless the discretion was not exercised judiciously.
Yeah.
This is what we submit. That means, one, there must be no facts that support the exercise of the discretion. The discretion must be exercised contrary to the legal principles. And you have not heard my learned friend arguing that that discretion was not exercised judiciously. We've referred His Lordship to a case of SABC versus NDPP. It's in our heads of argument, paragraph 667 of that judgment, where the Court clearly states that an appeal court can only interfere with the exercise of that discretion if it was not exercised judiciously. And we submit in this case, the applicants are not showing that that discretion was not exercised judiciously. The point being argued before you, my lord, is this, that Section 173 ought to have been pleaded. Unfortunately, there is no authority for that, because a Section 173 inquiry would arise simply because one of the parties has not, in the circumstances of this case, simply because the applicant has not taken steps to prosecute the matter.
Yeah.
So the respondents would not have had an opportunity to raise that in the answering papers. But in this matter, we know it was raised in the heads of argument that were served about 5 days or 6 days before the applicants filed their heads of argument. They didn't take the challenge to deal with that point, because the point is made clear that this application must be dismissed simply because the applicants have unduly delayed to prosecute. Whether the court concludes at the end of the inquiry that that amounts to an abuse of process, or whatever term it uses at the end of the day to categorize or to arrive at a conclusion, is neither here nor there. On the pleaded case, at least in the heads of argument, it is shown that there has been a delay. The delay has been caused by the applicants. They were not interested in prosecuting the appeal. The respondents had asked this court to dismiss the application simply on that basis, which is what the court has done. So we submit that there is no other court that can interfere with that discretionary power, the exercise of that discretionary power by this court.
Yeah.
Next, moving then, my lord, I would leave that and submit that this matter should end there in the first place. But we will address the issues that are raised by my learned friend insofar as the reasons. Firstly, let's first deal with the reasons issue. He says that the reasons were not adequate. That's what they argue now on the application for leave to appeal. If one goes to the notice of application for leave to appeal, it will be at 016-1, but in particular, let's go to 016-3. Paragraph 4 thereof. They say the learned judge erred in finding that the reasons given by the NDPP amounted to adequate reasons in law, which meet the requisite test. Now, they are shifting their case a little bit to say, we're now dealing with the adequacy of the reasons. But in the founding papers, what they had argued and pleaded was that there were no reasons whatsoever that were given for the decision, which is a different case to one arguing a case that says the reasons are inadequate. Because if one says the reasons are inadequate, he must show what the reasons do not address, so as to lead to a conclusion that they are inadequate. But it's a different story totally when you say there are no reasons. The court finds that there were reasons, but the reasons were the same reasons that were given in the process from the DPP Northwest until the 30th of June, when they were given the reason, the letter by the NDPP. The NDPP says, I find no reason to interfere with this because it prima facie, there is a case that you must answer. That they wanted further reasons which were not based on any new grounds that they are raising cannot mean that there were no reasons whatsoever.
Yeah.
So we submit that on that ground as well, they do not have prospects of success. Then my learned friend deals with what he calls the Gijima Khumalo argument. Our submission is this. Firstly, one must identify that the Gijima Khumalo principles apply to a delay before the institution of the review proceedings. In the Asla judgment, this lordship would be well aware of this. In the Asla judgment, the principle that is made by Theron J is simply this. One, even if you delay under the principle of legality to file a review, you still have to give an explanation for your delay. Even though you are not going to ask for, you are not going to apply for condonation formally, but there must be an explanation for your delay, which is what our authorities are saying. Our jurisprudence is clear that in legality reviews, you don't need to apply for condonation, a formal application for condonation, but still, you must have an explanation for your delay. That explanation is lacking in these proceedings before His Lordship. They never explained why they took 7 years to prosecute a review. And what we know from our jurisprudence is that a delay non-suits a litigant, whether before the institution of the proceedings or in the exercise of a Section 173 power post the institution of the proceedings. But as a matter of principle, our jurisprudence is clear on this regard that a litigant may be non-suited for that reason alone. His Lordship has referred to the Kasamji judgment of the SCA in his judgment. We have also shown, we referred to some other authorities, the Florence authorities, in our heads of argument that deal with the same issue, that once you delay unreasonably, the court is at large to dismiss your application simply on the basis of that, especially if there's no explanation. So we submit that there's nothing new in what our learned friend is arguing, and there's no basis whatsoever for this court to grant this leave to appeal on the grounds that he has set out. Then the other issue that they raise is the lack of credibility of Mr. X. This is a very absurd argument.
Well,
very
I think
absurd.
before you get there, Advocate Matebesi, can you deal with Mr. Mpofu's argument regarding the ex post facto reasoning basis that that's found in my judgment? That is that even if the reasons provided in the first letter are not enough, there were reasons provided in the answering affidavit. He says the SCA has said that's not allowed. I want to hear you on that.
Firstly, the answer that we have to that, my lord, lies in his admission in the first place, or concession that there are reasons that were given in the letter which they say they are inadequate. So there were reasons, even if there were other reasons given in the answering affidavit, and even if this court would have rejected those reasons as ex post facto, the issue would remain that there are reasons that were given. So his argument that there were no reasons in the founding affidavit would not have seen the light of the day, in the light of the fact that there are reasons, which is what this court finds, that there were reasons given, but this court goes on to say, in any event, in the answering affidavit, there are further reasons given. The SCA does not say you cannot give further reasons in an answering affidavit. What it says is that you cannot change, firstly, from the reasons that you had given as initial reasons. And secondly, what it says is that you can't, after having failed to give reasons, then seek to give reasons in an answering affidavit, because it becomes ex post facto reasoning of a decision, which is not applicable.
The SCA factual matrix was no reasons were submitted, and the attempt was to submit those in the answering affidavit. Exactly,
that's what they are talking against. To say you can't, when you have not given reasons, then seek to give reasons in the answering affidavit. but which is a totally different case to what we're dealing with here.
Okay. Well, you remember the applicant's case was that there are no reasons because they based their case on the second request for reasons.
Yes.
Where there was no answer.
Yes, ma'am.
And Advocate Mpofu has argued that the most important supervening or intervening factor was the meeting that happened with the NDPP, and the request emanated thereafter. So there was a need, an obligation to provide reasons after that engagement.
But what the applicants miss in this instance is one, that after the 13th of September, in fact, in the meeting of the 13th of September, there is nothing new that was said by the applicants to the NDPP relating to the decision.
Yeah.
So those decisions that he had given would still be valid as decisions, those reasons that he had given with his decision on the 30th of June would still be valid as reasons given for his decision, especially there not being anything new, especially that they had not submitted anything new in the meeting of the 13th of September. But in any event, in our answering affidavit, we don't provide reasons post 13th of September 2017. We provide reasons for the decision that we took on the 30th of June, which are the same reasons that we had provided to them, albeit that we have provided them in a shortened form in the letter that was on the 30th of June. So there's nothing new that we included in our answering affidavit relating to the reasoning of the decision.
Yeah.
So we submit that there are no prospects of success even on that issue. I was about to get to the issue of the lack of credibility of Mr. X, and the submission we made here is this is a very absurd kind of argument. One, it is absurd because it suggests that simply because one witness out of a number of other witnesses happened to have been discredited in another platform, that means that you can't continue with prosecution as the NPA when you've got a list of about other 75 witnesses that can still testify in the matter. It's absurd to suggest that. And secondly, there is nothing even in the papers of the applicant that suggests in the slightest that the rest of the other witnesses do not know anything about what happened in Marikana. We say in our answering affidavit, these are the witnesses that we are going to call. Even if that Mr. X may be discredited in court, assume he goes to court and testifies. But the rest of the other evidence of other witnesses would still be there for evaluation by the court as against what Mr. X says, even if he's discredited. That's how criminal proceedings, or in any event, that's how trial proceedings are conducted. You take the evidence holistically as a whole, you decide which one to accept, which one to reject, based on what. So that the fact that Mr. X was discredited as a bad witness, but ultimately, even the Falam Commission says there are portions of his evidence that are found to be reliable, which is what the DPP also considered when he asked for the transcript of the recordings of the Falam Commission and also the findings of the Falam Commission. My learned friend argues and says that the importance of Mr. X, he is an important witness because even the NDPP called for a transcript or a record of the Falam Commission to consider what was said about Mr. X in the Falam Commission. Obviously, the NDPP had to do that because this is the witness that they had identified to the NDPP that he was not a reliable witness. So for the NDPP to be able to deal with that complaint that was in their letter, he needed to look at what was said about this witness. It is not that this witness is more important than the rest of the others. This is where they miss the point. They had specifically referred to this witness and said, Mr. X is a bad witness, you can't rely on him. Then the NDPP says, okay, bring me that record so that I can be able to look at it for myself and see if indeed what they are saying in their complaint is valid. So it doesn't suggest that Mr. X is a very important witness.
Well, I think you've made your submissions. I mean, the issue is you say Mr. X is not the only witness. There are other witnesses. I think that's the case.
That's the point that you're making. For those reasons, my learned friend then argues that there's a compelling reason why the appeal must be heard. And this compelling reason is not based on the judgment. Unfortunately, what the appeal court deals with is the judgment. The compelling reason must arise from the judgment. Why do you say there's a compelling reason that the appeal must be heard? Is the judgment against established precedent? Is the judgment engaging a point of law that is very important, that requires the adjudication by another court? That's not what my learned friend is saying. All that he is saying is that Marikana arose 12 years back, but that's known to everybody, and it has nothing to do with the judgment, with the findings in the judgment. So
I think he argued at the beginning, if you heard, when he was arguing on the Section 173 approach, to say the courts are allowed to regulate their own processes. So you can't elevate the resort to Section 173 as a court to go to substantive legal rights. You can only stay on procedural issues. And he said he is not quibbling with that, but there's nothing like that in all the authorities. And if it's the development of new law, then it must go upstairs. That would be a compelling reason, wouldn't it?
But my lord, with respect, we disagree with that.
Okay.
Because Kasimji, that's what it says, that at some point, really, the rights of a party under Section 34 may be affected by the invocation of Section 173. But that does not mean that the courts must shy away from invoking Section 173. Because if there is an abuse of a court process, the courts are entitled, in the exercise of their inherent power under Section 173, to dismiss applications that are tainted with an abuse of court process.
Mm.
So it's really not a new thing, and courts have pronounced themselves on this issue. And it doesn't mean that the court, indeed, in invoking Section 173, is getting into the substantive merits of the matter. No, it's like any other delay. A court doesn't get into the merits of the matter. All it does is to pronounce that there's been a delay here. The delay is undue. These parties ought to be non-suited because of that.
Yeah. Well, I think Mr. Mpofu didn't identify the right, the substantive right that was affected by my ruling, relying on 173. But one can surmise that that right is the access to court.
Yes.
Isn't it? But well, he'll deal with that when he comes back on reply.
Yes, well, that's what I think he was saying, referring to Section 34. But we say the courts have been alive to that in the previous cases, to even mention it specifically that Section 34 rights of a person may be affected by this, but it doesn't mean that courts should shy away from exercising 173. Those are our submissions. We submit that this application should be dismissed. This time we seek costs against the applicants.
Okay.
As the court.
You want costs. Okay, thank you, Advocate Matebesi.
Thank you.
Reply, Advocate Mpofu. You are muted, Advocate Mpofu.
Yes, thank you, my lord. JP, I'll try to be quite brief again. My learned friend, just to get rid of something very quick, says that the fact of the 12 years must come from the judgment. But that's the very first sentence of the judgment says, introduction, this is a review application that has its origins in the events that took place in Marikana in 9 to 16 August 2012.
Yeah.
So it's not something that we're just making up. It's something that the court found to sufficient to include in the judgment. So it arises from the judgment.
Yes.
But your lordship is quite correct, and I'm sorry to start at the end, but it's just because I couldn't resist that point. But your lordship is quite correct that under compelling reasons, assume everything else I have said is wrong. Under compelling reasons, surely, and my learned friend had no answer to this, If it is indeed so that your lordship overlooked, and I'm using that word loosely, the Gijima principle, for example, or used the Kumalo principle without applying the Gijima principle. And I must not be heard to be saying that Gijima overruled Kumalo. No, that's not what I'm saying. Gijima simply developed the law to a further point to say the Kumalo test is not the end. You should go further. So I'm not saying the court applied something that was overruled by the Constitutional Court. No. But just that dichotomy between the Gijima principle and the Kumalo principle, which was applied by the court, surely is sufficient compelling reason for this matter to be sent to the other level. And by the way, I'm the first one to admit that the Gijima principle is a very hotly debated matter both in academia and in our courts. And even, I think it was Cameron and Fronem and Jay who gave a separate judgment in Asla. They grumbled about it, but they said, well, it's binding because that's what Gijima said, and we have to follow it. And they tried to find ways around it, but it's a compelling enough reason for a matter like this to be sent to the higher courts. And that's just on the Gijima versus Kumalo thing. But also, even if you looked at it from the point of view of this issue about the abuse of court versus undue delay, that's a major constitutional question as to the ambit of Section 173. Forget Gijima and all those things. But the point that we make, my lord, is, and the lordship is quite correct, that the substantive rights that we refer to are not, in this case, not only Section 34, that's the obvious right that one is talking about. But remember, this is a criminal matter, so we are also talking about Section 35. So it's Section 34 and 35 rights which are implicated in this particular case, and on the even on the higher test, and under Section 35, obviously, you have to take into also account in all sorts of other issues, presumption of innocence and so on. But broadly speaking, it's Section 34 and 35 rights that are implicated. And it's a serious question, this, as to whether Section 173 can be used beyond procedural issues. It's not a small matter. And as long ago as 1997, in a case called S versus Pennington, Chaskalson said, S versus Pennington, 1997, 4 SA 1076. Chaskalson said at paragraph 22, Section 173 of the 1996 Constitution gives this court, quote, an inherent power to protect and regulate its process. It is a power which has to be exercised with caution, and the reasons are obvious. I've already articulated them. So it's not it's the wider the power, the more cautious, obviously, and with all the qualifications that it has to be applied. The court can't just say, well, I know that nobody spoke about abuse of process, but I'm saying this is an abuse of process, because there's a jurisprudential difference between undue delay, simpliciter, and abuse of court. Abuse of court imputes some bad intent type of thing. So it's not, you can't just flip the other, as my learned friend says. He says he pleaded it in the heads. Well, that's not good enough. You can't plead something so drastic in the heads of argument, because then he must also live by his own rules. That means he deprived us of an opportunity to deal with it if he only pleaded it in his head. Okay. And those, so I'm trying to kill two birds with one stone. I'm dealing with the substantive Section 17.1a Roman 1 and 17.1a Roman 2 at the same time. which is the compelling reasons.
Yeah.
Then, just to round up some of the points, sorry, I've just lost my notes. Sorry, thanks. Sorry, JP. And just to round off this point I just made, your Lordship will find where the attribution of the motive on part of the applicants is, you'll find it on paragraph 44 of the judgment. And we say that may or may not be the case, but the court should at least have been favored with argument by the parties on that point as to the motives, because a delay may be innocent or it might be culpable in a particular context, but that issue alone must be argued before it can be graduated to abuse of court. Then the issue of the reasons, I don't know if my learned friend understands the crux of our complaint here, and maybe it's our fault, maybe we didn't articulate it properly. What we're saying, JP, is that it's common cause that in the second letter, the one that is quoted in the judgment, there were no reasons. There's no doubt about that. Because the only reason, and that letter is fortunately quoted in the judgment at paragraph 57, and it just says, I remain unpersuaded. That's not a reason. So there were certainly no reasons given. And
are you saying, looking at the initial response and what it said, it amounts to no reasons? So there were no reasons, effectively.
Yes, absolutely. Okay. Yes, yeah. That's the case. But I go further, JP, and say that it's not correct what my learned friend says, that the principle coming from the SCA only applies where there no reasons have been given. That's not true. If you go to the Zuma case, and you'll remember the facts of this are well known. It was the case where Advocate Mshe had given reasons for refusal to prosecute. And then later in the answering affidavit, they then came with a whole lot of nice reasons. And the court said, no, it doesn't matter. And the court said at paragraph 24, on 6 April 2009, Mr. Mshe announced publicly that he had made the decision to discontinue the prosecution of Mr. Zuma and issued a detailed media statement providing the reasons for the decision. So the reasons were given. And then the court says, it is against those reasons and those reasons alone that the legality of Mr. Mshe's decision to terminate the prosecution is to be determined. And then the footnote refers to the National Lotteries Board case. So my learned friend is wrong on both counts. A, there were no reasons, but B, even if we use the reasons in the first letter, the principle still applies in the sense that the answering affidavit reasons should have been discarded. So I just wanted to clarify that. Then, my Lord, with the greatest respect, I mean, to now accuse, just to touch on the condonation point, to again want to attribute ulterior motive on the part of the applicants in a case that has been here for 12 years just because of a 30-day delay is really just flogging a dead horse. I mean, what possible advantage are they going to get by a couple of weeks delay in the context of this matter as a whole? And I have considered that the attorney's affidavit could have gone into more detail, but one cannot trivialize the amount of work that needs to be done, because you can't just say I'm going to do an application for leave to appeal if you don't have proper instructions from all the clients.
Yeah.
And this issue about whether they were out of the province or out of the country is also just being exaggerated, because all the attorneys said is that some of the people went back to where they came from, and he found some of them out of the country. Whether they were there because they have relocated, I think he actually uses the word relocated, is neither here nor there. The point of the matter is that these people were more difficult to consult with, and the 15 days was not sufficient. But there's no ulterior motive that can be ascribed. Yes. Yes. Okay. The last point is that the Mr. X point is also being misrepresented. All we're saying, we accept. I said that even in chief. I accept that my learned friend has other witnesses. That's common cause. But the point we're making is that to the extent that we allege that Mr. X is the heart, is the nucleus of that evidence, nobody said we are talking nonsense. We have another 65 witnesses. They themselves went and investigated this thesis. And when they find that it's not as hot as it should be, now they want to shift the goalpost and say, oh, well, in any event, even if he's discredited, we'll have another 65 witnesses. They should have said that at the beginning, not after doing the exercise, if it was so outrageous. As the court places. Yeah. Oh, and cost. No, well, on our respectful submission, even if the leave is not granted, there's no basis to depart from the normal cost order, and the by-watch principle obviously applies. But should we be successful, we would pray that the cost in the appeal as a court blessing.
Okay. Thank you, Advocate Mpofu. Thank you also, Advocate Matebesi. I'm going to reserve my reasons. These will be emailed to your respective attorneys in due course. Thank you very much. This brings us to the proceedings.
Okay.
Thank you.